This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to BRD. By the way, our Thursday edition couldn't be more timely given everything that's happened yesterday in the Supreme Court. And I'm sure tomorrow we'll be doing the big show and we'll be dealing with probably, I would guess, we may touch on Maxwell and this and some other stuff. But Gary, why don't you set up what happened out of Mississippi, if I'm not mistaken?
Yeah, absolutely. So the case facing the Supreme Court right now is Dobbs versus the Jackson's Women's Health Organization. And the issue is basically whether all viability prohibitions on elective abortions are unconstitutional. So the Mississippi Solicitor General, Scott Stewart, is arguing for the state, and he is basically saying that Roe and Casey haunt our country and have poisoned the law, choked off compromise, and it should be left up to the people to decide. And I think there he's alluding more to the states than the people themselves, but so be it. And then
right, I think he's alluding to when they say let the people decide. That's kind of the position on the right, and I think you'll see that when we play a little Kavanaugh tape, that the idea is that this should be a decision by the legislatures and that the court should not be involved, which I kind of find funny when you take a look at it, and I'll comment on the other side. But so basically the argument in front of the Supreme Court was yesterday. A lot of people have characterized this as the demise of Roe, and basically moving the period of viability for those who are in the weeds here forward or backwards to 15 weeks. And so I think the Kavanaugh exchange with the lawyer on the opposite side of Scott is pretty instructive if you want to play that.
Yeah, absolutely. Let's check that out right now. Boom, boom.
I think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion, and they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue rather than continuing to pick sides on that issue. So I think that's, at a big picture level, their argument. I want to give you a chance to respond to that.
Yes, a few points, if I may, Your Honor. First, of course, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreements can't be resolved in a way that a woman has no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty. The court has interpreted that liberty to include the ability to make decisions related to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor, and if they're not able to make this decision, if states can take control of women's bodies and force them to endure months of pregnancy and childbirth, then they will never have equal status under the Constitution.
Right. And so let me kind of weigh in here. I think that argument that, as expressed by Kavanaugh, is disingenuous. I do not think that you can say that you're being neutral. And let me explain why. If you kick this back to the states, and mind you, he's correct when he says there is no abortion in the text of the Constitution. However, this has already been litigated in terms of the right to privacy. There is a right to privacy. in the Constitution. In California, there's a right to privacy in the California Constitution that is even more expansive and more delineated. But in the federal Constitution, it's been interpreted for over 5 decades that the right to privacy encompasses all kinds of things. It encompasses, by the way, gay marriage, because if you go down the line, that's where that comes in. The sodomy rulings, when there were anti-sodomy laws at the state level, they were invalidated as a result of the constitutional invasion of the bedroom. So if you're going to overturn the Roe, and I don't, by the way, I'll get to this, I don't think they're going to so much as overturn Roe as whittle away at it, and whittle away by moving the viability from 21 to 24 weeks back to 15 weeks, and then do something like they've done with the Texas law. And remember, I'm old enough to remember when this was criminalized. And when I say criminalized, when my father was a district attorney and I was a kid, he used to prosecute doctors and women who got abortions. Doctors were charged with murder in the state of California, as progressive as people want to say we are. And women would be prosecuted and then flip on the doctors in order to convict. So when you say that we're going to remain neutral, yet you're going to allow states to criminally prosecute, that points out the fallacy, the intellectual bankruptcy here. Now, the dissents were saying or asking questions, and the dissents, I'm assuming there's already a decision, but let's just say the so-called liberal wing, we're making the argument, or that if you take away, after 50 years, you have destroyed the court's intellectual heft and legitimacy. And I think that's true. I think that's a valid point. And be careful what you wish for. I think you're going to give fuel to the fire for those who want to expand the court. And you're going to end up destroying the court as an institution. And I think it's intellectually disingenuous to say that the court is taking a neutral position. The court isn't taking a neutral position. The court is taking an advocating position that, by the way, will be interesting when they come out with this ruling. We will play side by side what Amy Jack Barrett said, what Gorsuch said, what Kavanaugh said when they were asked the same questions at their confirmation hearings. And I think you're going to be it'll be very entertaining as to how they didn't have an opinion, but now they do have an opinion, and how they cloaked it at this point.
Yeah, absolutely. Justice Sotomayor was quoted as asking, will this institution survive the stench that this creates in public perception that the Constitution and its reading are just political acts? I don't see how that is possible.
I think it's clear. I think this has been an effort over a number of decades to overturn a decision they don't want. This is not Dred Scott. I mean, that's offensive when people say that. Dred Scott, we could do a whole show on the differences between Dred Scott and what is happening here. Remember, if this comes to pass, what we think it is, there will be states that will say, if you get raped or conceive as a result of incest, that you must have that baby. That's what it's going to be. I don't know. It's been 50 years, 45 years since this has been around. It's been kind of accepted as a constitutional right for women, and it's just astonishing to me that this is really the tyranny of the minority, because this is not the majority.
Yeah, it's definitely not. It's definitely concerning the things that are coming out of this. Do you have a sense of how much longer this process will play out?
Oh, I think that you're going to have a decision. I think the only question is it 5-4, 6-3, and whether, you're counting votes. I do not think that Chief Justice Roberts is is going to go for a Roe versus Wade, kind of saying that we're not going to wait in this anymore. I think he's shown that he wants to make incremental changes. And so prior to Justice Amy getting involved, I would have said that this could have been like an Obamacare redux. Now that she's in the mix, it'll be very interesting as to how she's going to navigate this based on her confirmation here in testimony.
Well, I mean, forgive my ignorance, but once you're confirmed, isn't that the ball game? I mean, what difference does it make?
Makes really no difference except, to quote Sotomayor, the stench that surrounds it.
Yeah,
That's where we're heading. The idea that somehow we're going to remain scrupulously neutral when you've been hijacked, I just think is the duplicitousness is overwhelming.
And that was my comment of who cares. I don't mean to trivialize the situation, but I don't believe that she is concerned with the stench or with, the differences from, so I agree with you.
We'll see. Kavanaugh is already, it's Roberts and Kavanaugh that I think are going to be ultimately how far they go, because Kavanaugh's already taken a bruising. And this is interesting. That's why we played his portion of it.
Yeah.
Because of the way he characterized this and the way that I think they want to go. They want to characterize this now as scrupulously neutral when it's anything but.
Absolutely. Well, we'll have an update on Saturday, hopefully, and we will definitely have an update on the Maxwell trial and much, much more. Mark, thank you so much for taking the time.
Thank you, Gary. Always good to see you.
Good to see you as well. All right, bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.